morning, everyone. Okay, so since it has been raining continuously for the past few days, I hope everyone is doing well and please stay safe wherever you are. And welcome again to our 12th episodes of the Strata Talk Show. With me again, Amiza, and I will be your host for tonight's Strata Talk Show. And this talk show is brought to you by Excel Academy of Real Estate. And Mr. Patrick will be our guest speaker for tonight's talk show. And for tonight's talk show, we'll be talking about challenging Strata Management Tribunal Awards. So, if you have any questions regarding this topic, please feel free to type your questions in the Facebook comment box below. And please don't forget to click on the share button and please share it with your friends, with your colleague, and also share it on your Facebook page. And hopefully by end of this session, we can entertain all of your questions. All right. So, hi, Mr. Patrick. How are you doing today?
Okay, well and good, well and good. What about
All
you?
right. I'm good too.
All right.
Okay. All right. So, without wasting more time, let's welcome Mr. Patrick to start the session right now. I'll pass to you, Mr. Patrick.
Thank you very much, Amisa. Good evening to each and every one of you. Welcome to this talk show. Today, the topic that has been given to me is about the Strata Management Tribunal, and more particularly or more specifically, how we can actually challenge the decision of the Strata Management Tribunal. Let me start off first and foremost by uh, telling you what the statute provides. And when we look at the statute, then maybe we will be clearer on what is required or what happens. Now, the statute, namely the Strata Management Act, in section 120 says an award made under section 112 sub 3 or section 117 shall, subject to section 121, be final and binding on all parties to the proceedings. It is final and binding and be deemed to be an order of a court and be enforced accordingly by any party to the proceedings. So, first and foremost, it is regarded as final and binding. Number two, it is just like an order of the court, right? There is no distinction in that sense. Now, what happens is when we look at section 117, section 117 talks about the awards of the tribunal. Okay? And it says here the tribunal shall make its award without delay and where practicable within 60 days from the first day the hearing before the tribunal commences. Now, there is no provision, I want to be very clear, there is no provision for appealing against a decision of the tribunal. I want to be very clear about this. Let us be quite explicit. There's no proceedings, there's no procedure for appealing against the decision of the tribunal. That is why it says that the decision of the tribunal shall be final. Now, what does it mean? You can still challenge the tribunal decision, but not by way of an appeal. You have to challenge the tribunal decision by way of judicial review. What is the difference between the two of them? Now, let us assume that you started a case in the Sessions Court. Your appeal will lie to the High Court. You have a right of appeal against any decision given by the Sessions Court. You can appeal to the High Court. Now, assuming your case started in the High Court, then you will have a right to appeal to the Court of Appeal. So everybody is given at least one opportunity to appeal. You sometimes will have two opportunities to appeal. For example, you may have brought a case in the Sessions Court, which is more than 250,000 in value, and then you appeal to the High Court, you lose, let's say, the High Court, you can still appeal to the Court of Appeal, right? Now, in an appeal, the Court of Appeal will actually, the appellate court, not the Court of Appeal, the appellate court will review the facts of the case as well as the law. So, from the record of the appeal, the court will look at the proceedings in the High Court, all the documents that were filed in the High Court, the witness statements, the proceedings in the trial court, all your cross examinations, everything will be there in the record of appeal, and the appellate court will review all the facts and determine from the facts whether the judge actually had a correct appraisal of the facts. Did he take into consideration all the relevant facts? Did he by any chance consider irrelevant facts? Or did he fail to take into consideration relevant facts? One part. Having dealt with that part, the appellate court will then look at the second part, which is, did the trial judge apply the law correctly? And then they will make a decision. Now, in this process, especially dealing with facts, the court also distinguishes between, the appellate court also distinguishes between a judge who had the opportunity and the advantage of seeing witnesses, the demeanor of witnesses, how they gave evidence, which any appellate court will not have the advantage of doing. That is an appeal. What is a judicial review then? In a judicial review, the court does not actually look at the facts. The court's jurisdiction, the High Court, from a tribunal, you file a judicial review with the High Court. The High Court has very limited jurisdiction. The High Court has to decide whether the processes were complied with. Now, please note, I do not use the word procedure, I use the word process. Whether the processes were complied with. Now, what is the process? Number one, the court will look at whether the Strata Management Tribunal, had jurisdiction to hear the case. The jurisdiction is listed out in Part 1 of the 4th schedule to the Strata Management Act. So it tells us what are the matters which can be heard by the Strata Management Tribunal. For example, the Strata Management Tribunal does not have power or jurisdiction to hear any issues regarding strata title. Right? They do not have jurisdiction. This is a Strata Management Tribunal. So their jurisdiction is limited to hearing matters regarding management. So disputes between management and parcel owners. That means this will involve disputes between the developer who originally manages the place, the JMB, the MC. Maybe there's a managing agent appointed by the court, by the COB, or an administrator appointed by the court, then they too can bring an action in the Strata Management Tribunal. The parcel owners can bring an action against any of the management bodies, be it the developer, the JMB, or the MC. So COB is also authorized to bring an action in the Strata Management Tribunal. Likewise, you can sue the COB also. This is management. The Strata Management Tribunal cannot resolve a dispute between two parcel owners. Let's say your parcel owner is being a nuisance to you. You will have to lodge a complaint with the managing body, GMB or MC. And if the GMB or MC fails to take action and you want to go to the Strata Management Tribunal, you will have to do so by suing the GMB for failing to carry out their duties and responsibilities. A dispute between a parcel owner and another parcel owner is not a management issue. It's only when you complain to the management and the management fails to bring an action against that parcel owner. For example, interfloor leakage, party wall damage. You complain to the management is supposed to bring an action against the party at fault. If they fail to do so, you take the management to the tribunal. If the management fails to do so, and you want to take a direct action against a parcel owner, you have to do so in court. You have to go to court. You cannot do it through the management. If you want, you cannot sue the owner in the Strata Management Tribunal. So you have a choice. Neighbor is causing problem. You want to save costs. You don't want to employ a lawyer. You notify the management. If they fail to do something, you sue them for failure to carry out their duty. Likewise, you can also go to the Strata Management Tribunal if you're unhappy with any resolution that has been passed at AGMs or EGMs, and you can challenge these resolutions in the Strata Management Tribunal, because decisions at AGMs and EGMs are part and parcel of management. This includes maintenance charges, sinking fund charges, failure of the management to maintain common property properly. So all this comes under the Strata Management Tribunal. All right, this is their jurisdiction. If the SMT does something which is beyond its jurisdiction, then this is one area where you can challenge it in the court via judicial review. Now, to give an example from another case called Hedgeford Sendirian Berhad. Hedgeford is a project which was developed in the Stapak area. And when the vacant possession was delivered, there was delay in delivery of vacant possession. There was delay in delivery of the common facilities. And so a number of owners brought an action in the Home Buyers Tribunal. Now, in the Home Buyers Tribunal, again, as usual, you are not allowed to be represented by a lawyer. But these home buyers were represented by other people, and the chairperson of that tribunal allowed them. The chairperson of the tribunal also calculated LAD from the date the booking fee was paid. So on both these issues, the developer challenged it in court. The developer said it is mandatory for the home buyers themselves to be present at the tribunal. They are not allowed to appoint lawyers. They are not allowed to appoint representatives. They should be there personally. Number two, the calculation of LAD was wrong. Now, in the judicial review that took place, the High Court made a decision that the Home Buyers Tribunal acted beyond its jurisdiction when it allowed persons other than the home buyers to be present at the tribunal and to give evidence and to represent the purchasers. So this is one example of a tribunal stepping beyond its jurisdiction, doing something which it is not permitted to do. As for the LAD, the High Court held that the calculation was correct. So the judicial review was only partly allowed, partly it was not allowed. So this is one example. Two, I will look at a case called Telekom Malaysia Berhad and Tribunal Tuntutan Pengguna and another, which was decided in 2006, in which the High Court judge at the time, 𝐒𝐿 gave the guidelines for judicial review. He said, if you can detect an error in the decision-making process, for example, the chairperson asks himself or herself the wrong question. That means what are the issues before that person, and the question they are asking themselves are wrong. Number two, they take into account irrelevant considerations. Number three, they omit to take into account certain relevant considerations. Number four, they misconstrue the terms of the relevant statute, or they misapply or misstate the principle of law. These are the grounds on which the court will allow a judicial review. So, of any Strata Management Tribunal, any home buyer tribunal, or any tribunal decision for that matter. So one thing is, if you go to the tribunal and a decision is given against you and you want to challenge the decision, it is by way of judicial review in the High Court. It will prove to be an expensive affair. High Court fees are not low, they're high. And you must be able to pinpoint where the chairperson made a wrong decision. Did they misunderstand the issue at hand? Number one, your issue is one thing and they talk about something else. Have they taken into consideration irrelevant factors? Or have they failed to take into consideration relevant factors? Have they misunderstood the Strata Management Act or the Strata Titles Act were relevant? Maybe regarding the powers of the JMB, the powers of the MC, maybe they failed to understand what is actually their powers. Excuse me. Maybe they have misapplied the law to the facts. Over and above this, you may be also able to challenge the decision of the Strata Management Tribunal on three important principles. One is what is called illegality. If the decision of the SMT is illegal. Number two, it could be irrational. And number three, it could be disproportionate. So there could be illegality. Example, the SMT acting beyond its jurisdiction. Simple example is a property manager cannot file a suit in the Strata Management Tribunal. However, the statute provides, if you have your Strata Management Act with you, and if you were to look at the fourth schedule, right, the fourth schedule will tell you what is the jurisdiction of the Strata Management Tribunal, right? Please look at it in the first part. The jurisdiction of the tribunal, the orders of the tribunal are given in part 2, right? So you look at that. Who can file a claim in the tribunal? Please look at section 107. It says a developer, a purchaser, a proprietor, including an original proprietor, a joint management body, a management corporation, a subsidiary management corporation, a managing agent, and any other interested person with the leave of the tribunal. So, who is this interested person with the leave of the tribunal? Then they can file an action. Nobody else can do so. Right? So, this is where the illegality can come in. Rationality is whether the decision is rational based on the facts of the case, based on the applicable law. Is it a rational decision? Number 3, proportionality. Can the award be considered as reasonable and proportionate to the findings? Maybe the chairperson finds the MC liable. That doesn't mean he can just go and impose whatever damages he likes. There are principles involved. Any damages that are being awarded must be proper, must be proportionate, must be rational, right? Now, the Act also says, and I would like to draw your attention to this part, that in section 113, that the tribunal shall act fairly and impartially as between the parties, giving each party a reasonable opportunity of presenting his case and dealing with that of his opponent. So they have to be fair, they have to be impartial, they have to give each party a reasonable opportunity. If the chairperson is somehow connected or has decided a case before involving one of the parties, preferably the chairperson should not act, for fear that it might be deemed to be partial rather than impartial. Now, I had a case in Ipoh where one of the parcel owners filed a claim against the JMB in the Strata Tribunal in Penang. Having filed it, after some processes, the case was fixed for hearing and the notice was sent by the tribunal to the parties to appear. Now, when you stay in a condominium, most of the AR registered letters are received by the management office. They inform the person, the parcel owner collects it. So in this case, the management office, for some reason or other, did not receive on behalf of the owner the AR registered letter from the tribunal. So on the hearing date, the JMB was there, the claimant was not there, and so the matter was struck out. The claimant then filed an application to reinstate, and after hearing the evidence from both sides, the reinstatement was allowed. The JMB was very unhappy, and the JMB challenged this reinstatement in the Penang High Court. At this stage, the claimant asked me to appear. I appeared, and after some delay because of the MCO, the SOPs, and there was a change of judges, even in the judicial review, the JMB's application for judicial review was thrown out. Right? Was thrown out. The matter was sent back to the tribunal. The matter is now going on in the tribunal. Now, when you go for judicial review, there are 2 stages. Stage 1 is what is called an ex parte application. In this ex parte application, if you are applying for judicial review, you file your papers through your lawyer. You file your papers in the High Court. The High Court will only hear your side of the argument, and after hearing your side of the argument, the High Court may or may not allow your application to go through. This is called the leave stage. There's a leave application first. Once the High Court allows you to file, then comes a second stage where now you have to serve all the documents on your opponent, and then the opponent will come and put in their affidavits and will challenge your claim. So it may take some time before the High Court makes its decision. From this tribunal decision, you can go by judicial review to the High Court. From the High Court, depending on what your claim is, less than 250,000, you need to apply for leave to the Court of Appeal to have an appeal heard. The court may or may not grant leave. If above 250,000, you can, but it won't happen because the tribunal's jurisdiction is limited to 250,000. They cannot give anything more than that. So you need leave application to High Court for judicial review, followed by the substantive hearing of the case, and leave to appeal to the Court of Appeal. The Court of Appeal allows, the substantive appeal will be heard. So basically, these are your challenges, these are your hurdles which you need to overcome in challenging the decision of the strata tribunals. In recent times, in the last few years, the government has invited through the Bar Council lawyers to act as chairman and chairladies of strata management tribunals, home buyers tribunal. So you will find more lawyers are sitting to hear cases, and so it will become a little bit more difficult to challenge them because the lawyers will be those who are already familiar with the law. I'm not saying the lawyers are perfect. They could still make mistakes. You could still challenge them. But more or less, that is how the situation will be today. Well, that is what I have to say regarding challenging the strata tribunal. So I will pass it back to Amiza. If you have any questions, I will see whether we can address those questions now. Over to you, Amiza.
Okay. Yes. All right. Thank you so much, Mr. Patrick, for sharing with us. There are some few examples that you shared. I hope everyone gain better understanding regarding this topic. So right now we are moving on to our Q&A session. Okay, I can see there are some questions coming from the participant tonight. I will pick one question coming from, hold on here. TF Tan. All right. So, Mr. Patrick, if the tribunal award has not compiled within 14 days, what can I do?
Right?
Pass to you, Mr. Patrick.
Okay. Now, as I mentioned earlier, if you look at the relevant section, in section 120, it says the decision of the tribunal is deemed to be an order of a court and may be enforced accordingly by any party to the proceedings. Okay? Now, it goes on to subsection 2, 120 subsection 2, which reads, for the purpose of paragraph 1b, in the case where the award made by the tribunal has not been complied with, the secretary shall send a copy of the award made by the tribunal to the court having jurisdiction in the place to which the award relates or in the place where the award was made, and the court shall cause the copy of the award to be recorded. So meaning, what you do is you go back to the tribunal and inform them that this person has refused to comply with the award. Now, from there, depending on how much is being awarded. Now, you note, if let's say compensation, we use compensation, simplest example, less than 100,000, you have to go to the magistrate's court. From 100,000 above right up to 1 million, you go up to the sessions court. So what will happen is they will send it to that particular court, and it will be recorded there. Then you pursue your remedy at that court. You can enforce it at that court. Right? You enforce. Let's say you are in KL Sessions Court, you enforce it in the KL Sessions Court, or you enforce it in the KL High Court, whichever court is suitable, depending on what the nature of the remedy is. You enforce it there. And if the person doesn't want to pay the court order, then you go for contempt of court. You can go for JDS, that is judgment debtor summon. Summon the person to come to court, ask them to pay. Right? Let me give you an example. I was in court 2 weeks back in Ipoh. This was an award given by court, not say award, damages the sum of 30,000 plus cost of 12,000, totaling 42,000, given some 3 to 4 years ago. Person refused to pay. We went for a judgment debtor summons, whereby the person had to come to court, magistrate's court, and show his income. After showing his income, I cross-examined him, I cross-examined the wife and everybody, and the court then made a decision. He has to pay 7,000 upfront, 2,000 every month until full and final settlement of the debt. That is called a judgment debtor summons. You can take that kind of action or any other action. Yes. Thank you. I hope that answered the question.
All right. Thank you, Mr. Patrick. That's a good example. I hope it answered the question that I've done. All right. Moving on to the next question coming from Hong Ji Wong. All right. I'll read the questions. Can I challenge MC on how they determine the water charges for individual parcel units, which was never adopted in any AGM on the ground the charges are excessive? The water company charges MC based on administrative decision at a rate of 1.60 cent per unit, while they charge parcel owners 1.85 ringgit. This is annualized return based on monthly return in excess of 180%. To me, this is a daylight robbery. All right. I pass to you, Mr. Patrick.
Okay, you say the water company charges MC based on administrative decision at rate of 160. Are we assuming that this is Shabas or Ayat Selangor, whichever company, water company which is charging? Now, the MC may charge a little bit more because it is a MC. This, I assume, that means this is block water. So the MC may be, all right, the MC may be giving the reason for this extra charge to be the maintenance cost for them. I really can't say, but you can write into the MC, ask them for an explanation, and if your explanation is not satisfactory, you can consult anyone and you can challenge it. You can challenge the MC decision in the tribunal. Yes, you may.
All right. Thank you, Mr. Patrick. So let's move to the next question. Don't I check first? Anyone, if you guys still have any questions regarding this topic, please feel free to write your questions in the Facebook comment box below. Yeah. So next, moving on to Encik Azman Ahmad. Okay, Mr. Patrick, thank you for sharing. My question is it necessary for the tribunal to provide written reasons or grounds for its decisions? Okay, I pass to you, Mr. Patrick.
Yes, they should give written grounds so that the parties can decide whether they need to challenge the decision or otherwise. So it is provided in section 117, subsection 2. It says, the tribunal shall in all proceedings give its reason for its award in the proceedings. So it could be an interim order, like the example I gave just now, where the tribunal allowed the reinstatement. So when the tribunal allows a reinstatement, even that is considered an interim award. Interim meaning in between, temporary, is not the final award, allowing a reinstatement. So the tribunal chairman has to give the reasons why they allowed the case which was struck off to be reinstated. Now that reason which is given will become the subject matter of the judicial review. So they have to give this. This is mandatory. It is given under section 117, subsection 2. Yes, I
Okay,
hope that answers the question.
all right. Thank you, Mr. Patrick. Thank you for sharing with us. Okay, so next questions. Moving on to from 𝐒𝐭𝐫𝐚. Mr. Patrick, at what point may we set aside a tribunal award? Okay, I pass to you, Mr. Patrick.
Okay, thank you. Now, according to the laws on judicial review, you have 90 days to file a judicial review application to set aside the award. From the date the award is given, you have 90 days to file an application in the High Court to set aside the tribunal decision. Right?
Okay, thank you, Mr.
I hope that
Patrick.
answers the question.
Yes, I hope it answered the question to Mr. Lee. Moving on to the next questions. Let me check again. Please, guys, please ask more questions so that we can maybe discuss about anything that you want to ask. So I'll pick from, okay, I think it's Siti Nur Ain. Okay, hi, Mr. Patrick. Can we opt to bring the claim before a civil court instead of the tribunal? I pass to
Right?
you.
Thank you. Now,
Okay.
here, section 106 says, where a claim is filed with a tribunal and the claim is within the tribunal's jurisdiction, the issues in dispute in the claim, whether as shown in the initial claim or as emerging in the course of the hearing, shall not be the subject of proceedings between the same parties in any court unless the proceedings before the court were commenced before the claim was filed with the tribunal, or the claim before the tribunal is withdrawn, abandoned, or struck out. Now, from section 106, it is very clear that parties have a choice whether to file a case in the tribunal or to proceed in a civil court. The decision to file in a tribunal or in the civil court has to be determined first and foremost by what exactly are you claiming for? Okay, what is the issue at hand? Are you claiming mismanagement? Are you claiming fraud? Are you claiming, abuse of powers? Are you claiming that your neighbor is being a nuisance? And secondly, who are you claiming against? Now, then you also have to decide what kind of remedy are you looking for. Now, for example, if the management decides to increase the maintenance charges and they have passed a resolution which appears to be unfair to you, it could be because it could be a mixed development, or it could be what we call a gated and guarded community, where you may have bungalow houses, semi-Ds, link houses, and the decision to increase the maintenance charges is not proportionate, right? It's not done proportionately. If you have that kind of situation arising, the power is given to the tribunal to nullify a resolution. You may, if you want to, apply that. Now, however, in the meantime, if you want to stop the MC or the JMB from implementing the resolution, then the tribunal does not have power to issue an injunction. So if injunction is what you're looking for, then you have no choice. You will have to apply to the High Court. only the High Court can give an injunction to stop the MC from implementing the revised rates. I did that in Ipoh for 6 of my clients in a gated and guarded community, where we got an injunction for these 6 people. They pay the old rate until the end of the trial. They will not pay the new rates. The others were paying the new rates. So if you want to choose to bring an action in the High Court, you can. However, I must put a caveat to this advice. There are decisions of the court which says that all internal proceedings and avenues provided in the Strata Management Act should be exhausted, should preferably be exhausted before you come to the court. Meaning, there are 3 avenues. Avenue number 1 is to call for an EGM, pass resolutions. This may be difficult if you are in the minority. Avenue number 2 is to go to the COB. The COB has some powers to even investigate. The COB can appoint their own auditors to audit the MC accounts or JMB accounts. They can appoint managing agents to manage the place if there is mismanagement. 3, you can go to the Strata Management Tribunal. If all this fails, you can still go to the courts. So generally, the High Court will expect you to exhaust your internal avenues first before going to the court. All right? Okay, thank you. I hope that answers your question.
Okay, thank you, Mr. Patrick. Thank you for giving the example as well. Okay, so moving on to the next question. It's from Encik Azman Ahmad again. Sir, another question. What happens if a party is absent during the hearing? Is it possible for the tribunal to continue with the hearing? I'll pass to you, Mr. Patrick.
All right, thank you. Now, Section 110 provides, at the hearing of a claim, every party shall be entitled to attend and be heard. It's very clear. Everybody has a right to attend and also to be heard. This, of course, must be read with Section 113, which I mentioned earlier, that the tribunal shall act fairly and impartially as between the parties. However, having said that, the tribunal also has the power to determine its proceedings. The tribunal has a power, for example, to prevent misuse or abuse. Now, for example, one party may simply try to delay matters by not attending and then saying, oh, I was sick, I was this, I was that. So the chairman of the tribunal has power to give warnings to the party and say, look, you cannot be absent so many times. If you continue to be absent, we are going to proceed in your absence. If that is the case, they may be able to continue. Now, if it is a claimant who is absent, then of course he may just strike off the matter. He may strike off the claim. But if it is a respondent who continuously delays, right, then they should proceed with the matter in the absence, and they should be stated in the grounds for the decision for the award. All right.
All right, thank you, Mr. Patrick. I hope this answered the question just now. And then moving on to the next questions, again from Mr. Hong Ji Wong. Can JMB say no to water migration on the ground as AJ Johor is ready to handle it for private high-rise? They only do for government projects only. Okay, I pass to you, Ms. Patrick.
All right. Now, this is a little bit difficult question to answer because the JMB can say, the JMB, of course, must take all efforts, all steps to ensure that every unit has its own water meter. But if the water authorities of the respective states, we must understand water is a state matter. It is dealt with by each state. So each state has its own rules, it has its own regulations. So taking Johor, for example, they will have their own rules and regulations. If they say, look, we are not going to provide water for high-rise buildings, the management has to provide on its own, then there's no choice. Then you cannot migrate, then that is the way it is going to be. Now, this will depend on state to state. Every state has its own rules. But the JMB must be sincere. They must be very transparent in what they're doing. You have a right to expect that the minutes of correspondence between the Johor Water Authority and the JMB is actually displayed and said, this is what they responded, this is what they responded. According to them, they are not going to supply water for us. They only will supply bulk, and we are expected to put in our own pumps and supply our own water. If that is the case, you can't blame the JMB or the management for that. But there must be transparency. There must be proper dialogue. There must be proper correspondence between them.
Okay, thank you, Mr. Patrick. Next, I'll pick. I don't know. All right.
Ravi.
This is from Ravin. Mr. Patrick, can a party be appointed by a lawyer in the hearing before the tribunal? If can, are the other party will also be allowed to? Pass to you, Ms. Patrick.
All right. Section 110 in subsection 2 says, no party shall be represented by an advocate and solicitor at a hearing unless, in the opinion of the tribunal, the matter in question involves complex issues of law, and one party will suffer severe financial hardship if he is not represented by an advocate and solicitor. Meaning, you can put forward and say, look, this is a very complicated matter. I am a layman. You cannot expect me to present my case as a layman, especially if you are the respondent and a claim against you, let's say, is some maintenance charges amounting to 100,000, 200,000. You can say the matter is very complicated. I cannot handle this on my own. And if you don't allow me to handle it on my own, and if I lose the case, it's going to cost me 100 or 1,000. It's a lot of money, and I can't afford that. That would be unfair to me. So that answers the first part of the question, right? Now, subsection 3, 110 subsection 3 says, if one party is allowed to be represented by an advocate and solicitor under subsection 2, the other party shall also be entitled. I mean, to be fair, if you allow A to be represented, B must also be equally represented. Okay? Now, subsection 5 says, where party is represented as permitted, okay, tribunal can impose conditions. Where this is for companies and other things. So there are conditions. Maybe the lawyer can only be allowed to represent you on certain issues, not on the entire proceedings. But if it's complicated and involves big sum of money, you can say, look, I need a lawyer to represent me. And if the tribunal allows you to be represented by a lawyer, they have to allow the other party to equally be represented by a lawyer also. This is statutory. Thank you.
All right, thank you, Mr. Patrick. So I think that is all for tonight because there's no more question coming from participant. All right, so before I end the session, thank you so much, Mr. Patrick, for sharing with us. So
welcome.
thank you also to everyone for joining our talk show tonight. I hope that Mr. Patrick answered all of your questions, and I hope everyone have a clear view on this topic as well. And hold on for a while before I end the session. I would like to invite everyone to join our upcoming seminar, which is on this upcoming 19 March 2022, next Saturday, with the topic of resolving dispute in strata scheme through the courts or the Strata Management Tribunal by Miss Saraswati Shirkedio. Okay, so if you are all interested to join the said seminar, you can contact our number as stated below 017-856-2228. Okay, I repeat again 017-856-2228. All right, and you can also register with us. So I guess that's the end of our session for tonight. Okay, thank you, Mr. Patrick, and thank you, everyone. Have a good night.
Thank you, everyone. Thank you, everyone, for joining. Uh, I hope I have satisfactorily answered all your questions. Good night. Stay safe.
You too,
All
Mr.
right.
Patrick. Good night.
Well, thank you.